Well, the ANC said that it would challenge the South Gauteng High Court's decision ordering it to provide the DA access to documents related to its cadre deployment committee meetings from 2013 to 2021. Now, on Thursday, the court gave the ruling party 5 days to comply with this request and to cover the litigation costs. The records include committees' minutes, WhatsApp conversations, emails and CVs. To unpack how the ANC could challenge this ruling, we're joined by legal researcher Nkanyiso Mulunga. Nkanyiso, thank you so much for your time and thank you for joining us this morning. Before we get into what exactly the ANC's cadre deployment committee is being asked to hand over, I think this is no doubt a watershed moment for the African National Congress to have this veil of secrecy, one of this size, one of this magnitude removed. So I'm assuming an appeal was pretty much unavoidable.
Good morning, Douglas, and good morning to the listeners. So basically here, there was an application made by Leon, and the application is with respect to the documents that includes the minutes of the deployment committee of the ANC, dating from the 1st of January 2013 up until January of 2022. So this application was culminated by the application that was made by the DA before the High Court, where they effectively want the High Court to declare that deployment committee is constitutionally invalid. But in this instance, the documents were sought by Leon, and then the DA had not sought the documents in the form of an application, but they were joined as also one of the applicants. So, and I think that it is important to firstly highlight what is the PIA Act, what does it mean, just briefly, because it is about the access to the information in terms of its rights that is in the Constitution in terms of Section 32. Where a public or a private entity organization may be compelled to release certain documents where it is deemed that it is in the interest of a protection of any right or in the exercise of any right. So the legislation provides that it can be sought. So in this instance, Leon had actually duly complied with the provisions of the Act that you must specify the information that you are requesting to the organization, of which I think he did. But the debate then became whether or not the DA had a standing to join such an application, of which the court found that they did not have a standing. However, they would just still remain as cited in the court proceedings. So I think that the judgment that has been given, it is being given in respect of Leon, that as the only person who's been able to clearly demonstrate in terms of the Act that they do have a certain particular right that they have to protect, or I think he was able to produce evidence to that effect, as the court says in the judgment.
Right. Well, the DA's argument, Nkanyiso, with regards to this particular matter is that the ANC's cadre deployment committee needs to be able to conduct itself in a manner that is open and transparent, and that only in doing it in that way can they actually foster any sort of accountability. What do you make of that assertion? Does the PIA Act pave the way for opposing political organizations to, in essence, impose this transparency and openness and accountability on each other?
No, the Act basically, I think the requirement in Section 50 of the Act is clear that the documents or the information that you must request is when there is a right, you are required or the exercise of or the protection of any right. So I think of any right in the Act is not defined, meaning it can be common law, statutory right, or a fundamental right. So what you have to do here is that you must be able to establish a causal connection between the information that you are requesting from that organization and the harm that you sought to avoid by requesting those documents. So meaning that you have to, the onus is on the person who requests documents actually to demonstrate, that what is it being reasonably required is that the information or the documents are so important that they intend to protect a particular right. So you have to adduce evidence, obviously, to that effect. And what we've seen is that Leon said that he is working on a legislation of which he attached as his evidence in court application that he wants to prevent cadre deployment because of what was said in the Zondo Commission. I think the president was at the Zondo Commission. He made certain concessions with regards to cadre deployment and other few witnesses who appeared before the commission. I think that's where one of the evidence that was not contested by the ANC in the application, I think that's when the court considered that particular evidence. But on the other hand, there is an ongoing application of it, is the main substantive application with regards to the cadre deployment in itself, whether or not it's constitutionally valid. I think the court is still seized with that separate application, of which I think the court would have to therefore determine whether or not the DA as well can bring such an application in terms of, do they have the standing, can they act in the public interest in respect of that matter. Understanding, obviously, our constitutional democracy, in a multi-party system. Obviously, we understand that a political party that wins an election will always obviously have its own people deployed in parliament or any other sphere of government or working for the state, because they would obviously often be required to have people whom I think in terms of policy framework they agreed. So it's a very complicated case for the DA, the main application. And I think also you would remember the case of Constitutional Court, the Ramakatsa judgment. I think the courts have been often very reluctant in interfering with political parties' internal affairs,
Right.
So, yes.
Right. We'll come back to that substantive issue because I think you've raised a very important point. But back to what exactly the cadre deployment committee has to hand over. We're talking minutes, we're talking WhatsApp messages, we're talking CVs of certain individuals. At which point does the handing over of this information become an infringement to the personal rights of those individuals who form part of the committee and those individuals who are likely to be implicated in whichever WhatsApp messages are eventually handed over? So the question here is to say that in complying with this particular court order, because we know the nature of WhatsApp messages can, of course, be personal. One's curriculum vitae can also be very personal in nature. So when does that potentially become an infringement to those individuals and the committee who have to hand it over?
I think the most important thing is that we now have the POPIA Act that allows organizations to be able to lawfully process people's personal and private information. So even their information, since it's been required to be handed over to the DA, so what's going to happen is that what is considered here, it's when you harmonize both rights, the right to privacy and what is a particular right that might be harmed once that has been demonstrated. So, and I think that the courts here, even in the past, have said that if a party that's requesting information has been able to demonstrate a protection or the exercise of the right, there's never really much of the considerations of people's personal privacy, because then the need to protect a right then supersedes that particular interest or that particular privacy in the documents, for as long as the party can also truly comply with the requirements of processing people's personal information. Right.
Now, coming back to that substantive issue, the matter that's also before a high court, whether or not the ANC's cadre deployment policy is even unlawful or unconstitutional, should the high court in that instance rule in favor of the DA, in terms of what, for instance, came out of the Zondo Commission of Inquiry, those concessions made by the president, what sort of implications will it have on this particular ruling, giving the DA access to these documents? Or perhaps, let me phrase it this way, if the court rules against the DA, rather, in the substantive issue, what sort of implications would it have on this ruling, giving the DA access to these documents?
I think that to some extent there is flaws in the cadre policy, but I do not think that the courts would have to declare it invalid because it encapsulates our constitutional democracy as represented by political parties in parliament. Because we know, for instance, that the DA is in charge of the Western Cape government, and people who work there, in as much as they are professionals, but they are largely associated with the DA, and just it is the case with the ANC. So the policy will, in my opinion, infringe upon that declaration will infringe upon the rights of political parties in our democracy to be able to exercise that right of having to have their own people in the government and formulate and form a government, you know. And my concern, secondly, is that since it has been acknowledged even by the courts that political parties are private entities, you know, are not public entities. So it raises also a question of whether or not the DA does have a standing to bring such an application. Shouldn't really be the ANC people, ANC members in good standing challenging the application, not the DA. And what makes the DA or what gives them a standing to bring such an application or challenge such a policy? And also you are asking if what would happen if the courts would rule otherwise, and notwithstanding the DA having the documents. And I think the DA may have the documents in their possession, as the court has ruled, and I think what the DA has said is that they need the documents for a particular issue, of which is the legislation in Parliament that they want to do. So, for instance, Section 7 of the PI Act actually prevents or precludes people to access information when there's a matter that is pending, either criminally or in a civil court.
Right.
So I think then, in this instance, there are pending proceedings, of which is the main substantive application of the DA. The documents have been sought for a different purpose, and evidence has been attached for that particular purpose.
Kanyisa, thank you so much for your time, and thank you for coming onto the platform and sharing your insights with us right now.